Sidley and Saul were married with one daughter, Solen. Sidfrey and Sonia were another couple with one son, Sonny. Saul and Sidfrey both perished in the same plane accident. Sidley and Sonia met when the families of those who died sued the airlines and went through grief counseling sessions. Years later, Sidley and Sonia got married. At that time, Solin was 4 years old and Sonny was 5. These two were then brought up in the same household. 15 years later, Solin and Sonny developed romantic feelings towards each other and eventually eloped. On their own and against their parents' wishes, they procured a marriage license and got married in church. Is the marriage of Solin and Sonny valid, voidable, or void? The marriage is voidable. Under Article 45 of the Family Code, a marriage may be annulled when, at the time of the marriage, the party in those behalf it is sought to have the marriage annulled was 18 years of age or over but below 21, and the marriage was solemnized without the consent of the parents, guardian, or person having substitute parental authority over the party, in that order. Here, since Solin is 19 years old and Sonny is 20 years old, they should have sought the consent of their parents, guardians, or persons having substitute parental authority over them. Failing to do that, their marriage is voidable. B. If the marriage is defective, can the marriage be ratified by the free cohabitation of the spouse? Yes, under Article 45 of the Family Code, such marriage may be ratified by the cohabitation of the contracting parties after attaining the age of 21 as husband and wife. Question 2. After finding out that his girlfriend Sandy was 4 months pregnant, Sancho married Sandy. Both were single and had never been in any serious relationship in the past. Prior to the marriage, they agreed in a marriage settlement that the regime of conjugal partnership of gains shall govern their property relations during marriage. Shortly after the marriage, their daughter, Shalimar, was born. Before they met and got married, Sancho purchased a parcel of land on installment under a contract of sale with a full purchase price payable in equal annual amortizations over a period of 10 years with no down payment and secured by a mortgage on the land. The full purchase price was $1 million with interest at the rate of 6% per annum. After paying the fourth annual installment, Sancho and Sandy got married, and Sancho completed the payment in the subsequent years from his salary as an accountant. The previous payment were also paid out of his salary. During their marriage, Sandy also won $1 million in the lottery and used it to purchase jewelry. When things didn't work out for the couple, they filed an action for declaration of nullity of their marriage based on the psychological incapacity of both of them. When the petition was granted, the parcel of land and the jewelry bought by Sandy were found to be the only properties of the couple. What is the filiation status of Shalimar? Shalimar is a legitimate child of Sancho and Sandy under Article 164 of the Family Code. Children conceived or born during the marriage of the parents are legitimate. Since Sancho and Sandy had been married when Shalimar was born, Shalimar is a legitimate child. What system of property relationship will be liquidated following declaration of nullity of their marriage? The regime of conjugal partnership of gains is the system of property relationship that govern the marriage of Sancho and Sandy. Article 75 of the Family Code provides that the future spouses may, in the marriage settlements, agree upon the regime of conjugal partnership of gains. Here, Sancho and Sandy agreed in their marriage settlement, which they executed prior to the marriage, that the regime of conjugal partnership of gains shall govern their property relations. Therefore, the conjugal partnership of gains is the property regime that will be liquidated upon the declaration of nullity of their marriage. Letter C. In the liquidation, who should get the parcel of land? Who should get the jewelry? The parcel of land is a conjugal property of Sancho and Sandy. Article 118 of the Family Code states that property bought on installments, paid partly from exclusive funds of either both spouses and partly from conjugal funds, belongs to the conjugal partnership if such ownership was vested during the marriage. Any amount advanced by either spouse shall be reimbursed by the owner upon the liquidation of the partnership. In the present case, the parcel of land was bought by Sancho on installment prior to his marriage with Sandy. As full payment was completed during their marriage, the ownership of the land was vested during their marriage. Hence, the parcel of land is a conjugal property subject to Sancho's right of reimbursement of what he has paid prior to the marriage. The jewelry is also a conjugal property according to Article 117, Number 1 of the Family Code. Those which are acquired by onerous title during the marriage at the expense of the common fund, whether the acquisition be for the partnership or for only one of the spouses, are conjugal properties. In the case at bar, what was used by Sandy to purchase the jewelry is the 1 million that she won from the lottery, which is provided by paragraph 7 of the same article, is part of the conjugal properties. Since the common fund was used to acquire the jewelry, the latter is a conjugal property. Upon dissolution of the conjugal partnership regime, the net remainder of the conjugal properties shall constitute the profits, which shall be divided equally between Sandy and Sancho, unless a different proportion or division was agreed upon the marriage settlement, or unless there has been a voluntary waiver or forfeiture of such share. Article 129, paragraph 7, Family Code. D. Is Shalimar entitled to payment of presumptive legitime? If yes, how much should be her share, and from where should this be taken? Yes, Shalimar is entitled to the payment of presumptive legitime amounting to one half of her parents' estate as their legitimate child. Under Article 888 of the new Civil Code, the legitime of legitimate children consists of one half of the estate of the parents. This presumptive legitime will be then taken from the net estate of the parents during the liquidation, partition, and distribution of the properties of the spouses pursuant to Article 51 of the Family Code. Silverio was a woman trapped in a man's body. He was born male, and his birth certificate indicated his gender as male, and his name as Silverio Stallone. When he reached the age of 21, he had a sex reassignment surgery in Bangkok, and from then on, he lived as a female. On the basis of his sex reassignment, he filed an action to have his first name changed to Shelley and his gender to female. While he was following up his case with the RTC in Manila, he met Sharon Stan, who also filed a similar action to change her first name to Sharif and her gender from female to male. Sharon was registered as a female upon birth. While growing up, she developed male characteristics and was diagnosed to have congenital adrenal hyperplasia, CAH, which is a condition where a person possesses both male and female characteristics. A puberty test revealed that her ovarian structures had greatly minimized, and she had no breast or menstrual development. Alleging that for all intents and appearances, as well as mind and emotion, she had become a male, she prayed that her birth certificate be corrected such that her gender should be changed from female to male, and that her first name should be changed from Sharon to Sharif. Silverio and Sharon fell in love and decided to marry. Realizing that their marriage will be frowned upon in the Philippines, they traveled to Las Vegas, USA, where they got married based on the law of the place of celebration of the marriage. They, however, kept their Philippine citizenship. Is there any legal basis for the court to approve Silverio's petition for correction of entries in his birth certificate? B. Will your answer be the same in the case of Sharon's petition? C. Can the marriage of Silverio, Shelley, and Sharon Sharif be legally recognized as valid in the Philippines? Letter A. In both instances, no, a person's first name cannot be changed on the ground of sex reassignment, since it is not among the grounds stated under RA 9048. Likewise, with respect to the change of sex from male to female, there is no law which allows the change of entry in the birth certificate as to sex on the same ground. The determination of a person's sex is that which appears in his birth certificate. Silveria versus Republic. Letter B. No. Where the person is afflicted with CAH or is biologically or naturally intersex, the determining factor is his gender classification, would be what the individual having reached at the age of majority. With good reason, think of her sex. Republic versus Kagandahan. Letter C. No, since Silveria is still a man and Sharon, upon approval of her petition, is now considered as a man, the marriage between them shall be void ab initio, as it is classified as same-sex marriage, violating Articles 15 and 17, paragraph 3 of the new Civil Code, as well as Article 1 and 2 of the Family Code. Silverino died intestate, survived by his wife Saturnina, and legitimate children Soler, Suplico, Segundo, and the twins Sandro and Sandra. At the time of his death, the twins were only 11 years of age, while all the older children were of age. He left one property, a 5,000 square meter parcel of land. After his death, the older siblings Soler, Suplicio, and Segundo sold the land to Dr. Santos for 500,000 with a right to repurchase at the same price within 5 years from the date of the sale. The deed of sale was signed only by the 3 older siblings and covered the entire property. Before the 5-year expired, Soler and Sulpicio tendered their respective shares of 166,666 each to redeem the property. Since Segundo did not have the means because he was still unemployed, Saturnina paid the remaining 166,666 to redeem the property. After the property was redeemed from Dr. Santos, the 3 older children and Saturnina, for herself and on behalf of the twins, who were still minors, sold the property to Dr. Sazon in an absolute sale for 1 million. In representing the twins, Saturnina relied on the fact that she was the natural guardian of her minor children. A. Was the first sale to Dr. Santos and the subsequent repurchase valid? Letter B. Was the second sale to Dr. Sazon valid? May the twins redeem their share after they reach the age of majority? Letter A. Yes. The first sale is valid, but only insofar as the share of the other siblings. Article 77 of the new Civil Code provides that the rights to the succession are transmitted from the moment of the death of the decedent. The heirs can convey their rights to third persons even before the settlement of the estate of the deceased. However, the effect of the alienation is limited to what is ultimately adjudicated to the heir who made the alienation. In this case, the sale by the older siblings affects only their respective shares. Also, the subsequent repurchase is valid. Article 1088 of the new Civil Code provides that should any of the heirs sell his hereditary rights to a stranger before the partition, any or all of the co-heirs may be subrogated to the rights of the purchaser by reimbursing him the price of the sale, provided they do so within 1 month from notice. Letter B. Yes, the second sale is valid and so far as the sale of the shares of the older siblings and their mother. The twin may redeem their share at the age of majority. Article 412 of the new Civil Code provides that the father and the mother shall jointly exercise legal guardianship over the property of the emancipated common child without the necessity of court appointment. Saturnina, being the mother of the twins, indeed, had legal guardianship over the property of the twins while they are still minors. However, the Supreme Court held in the case of Neri versus Ears of Uy, the parent's authority is only for acts of administration and does not include acts of ownership. A father or a mother, as natural guardian of the minor under parental authority, does not have the power to dispose or encumber the property of the latter. Such power is granted by law only to a judicial guardian of the ward's property, and even then, only the court's prior approval secured in accordance with the proceedings set by the rules of court. Therefore, the mother having no judicial authority to sell the property of the twins, the sale as to does not include the share of the twins. Sol Divina, widow, passed away, leaving two legitimate children, a 25-year-old son, Santino, whom she had not spoken to for 5 years prior to her death, since he attempted to kill her at that time, and a 20-year-old daughter, Sarah. She left an estate worth $8 million and a will containing only one provision, that $1 million should be given to the priest who officiated at my wedding to my children's late father. Sarah, together with two of her friends, acted as an attesting witness to the will. On the assumption that the will is admitted for probate and that there are no debts, divide the estate and indicate the heirs or legatees entitled to inherit, the amount that each of them will inherit, and where, like legitimate or free portion intestate share, their shares should be charged. Santino and Sarah shall be entitled to half of the estate of their legitimate. Thus, they are entitled to $4 million collectively, or $2 million each. The legitimate of legitimate children and descendants consist of one half of the hereditary estate of the father and of the mother. The priest, being a legatee, is entitled to his $1 million, as provided by the decedent's last will and testament. This share is chargeable to the free portion of the hereditary estate. The remaining $3 million shall be subjected to the rules of intestate succession. Sarah is incapacitated to inherit since she was an attesting witness. Sammy and Santi are cousins who separately inherited two adjoining lots from their grandfather. Sammy is based overseas but wants to earn income from his inherited land, so he asked a local contractor to build a row of apartments on his property, which he could rent out. The contractor sent him the plans, and Sammy noticed that the construction encroached on a part of Santi's land, but he said nothing and gave approval to construct based on the plans submitted by the local contractor. Santi, based locally and who loved his cousin dearly, did not object even if he knew of the encroachment, since he was privy to the plans and visited the property regularly. Later, the cousins had a falling out, and Santi demanded that the portion of the apartments that encroached on his land be demolished. Can Santi successfully file legal action to require demolition? No, Santi cannot successfully file a legal action to require demolition. Article 453 of the New Civil Code provides that if there was bad faith not only on the part of the person who built on the land of another, but also on the part of the owner of such land, the rights of one and the other shall be the same as though both had acted in good faith. There is bad faith on the part of the landowner whenever the act was done with his knowledge and without the opposition on his part. Here, Sammy acted in bad faith when he approved the construction despite knowing that it encroached upon Santi's land. Santi also acted in bad faith, for he did not object, even if he knew of the encroachment. Therefore, both of them is deemed to have acted in good faith. Demolition, consequently, cannot be had. The only remedy herein, as provided under Article 448 of the New Civil Code, would be the appropriation by Santi of the construction built on his land, after payment of indemnity, or to oblige Sammy to pay the price of the land. Question 7. Sydney, during her lifetime, was a successful lawyer. By her own choice, she remained unmarried and devoted all her time to taking care of her nephew and two nieces, Socrates, Saphinia, and Sophia. She wrote a will giving all her properties remaining upon her death to the three of them. The will was submitted to probate during her lifetime. Later, she decided to make a new will giving all remaining properties only to the two girls, Saphinia and Sophia. She then tore up the previously probated will. The second will was presented for probate only after her death. However, the probate court found the second will to be void for failure to comply with the formal requisites. A. Will the doctrine of dependent relative revocation apply? Will your answer be the same if the second will was found to be valid but both Safinia and Sophia renounced their inheritance? Letter A. Yes, the doctrine of relative revocation will apply. Under this doctrine, when a first will is revoked, to connect with the making of the new will, so as to fairly raise the inference that the testator meant the revocation of the old will to depend upon the efficacy of the new disposition, if for any reason the new will becomes inoperative, the old will shall remain in force and the prior revocation is deemed void. Letter B. No, even if the instituted heirs in the second will renounce their rights to the inheritance, it does not have the effect of revocation of the will, as would permit the application of the doctrine of dependent relative revocation. The effect will just pave the way for intestate succession and not the revival of the previously revoked will. Question 8. Sophronio was a married father of two when he had a brief fling with Sabrina, resulting in her pregnancy and the birth of their son, Sinforoso. Though his wife knew nothing of the affair, Sophronio regretted it, but secretly provided child support for Sinforoso. Unfortunately, when Sinforoso was 10 years old, Sophronio died. Only Sophronio's father, Salumbides, knew of Sabrina and Sinforoso. For the purpose of providing support to Sinforoso, Salumbides gave Sabrina usufructuary rights over one of his properties, a house and lot, to last until Sinforoso reaches the age of majority. Sabrina was given possession of the property on the basis of caution juratoria. 2 years after the creation of the usufruct, the house accidentally burned down, and 3 years thereafter, Sinforoso died before he could reach the age of 18. Will the usufruct continue after the house has burned down? If yes, will it continue after Sinforoso's death? Suggested answer number 1. Yes, the usufructuary will continue even after the house has burned down. Article 607 of the New Civil Code provides that if the usufruct is constituted on immovable property of which a building forms part, and the latter should be destroyed in any manner whatsoever, the usufructuary shall have a right to make use of the land and the materials. In this case, since the usufruct was constituted on the house and lot, the usufructuary will continue even after the house has burned down. Number 2. No, the usufructuary will not continue after the death of Sinforoso. Article 603 of the New Civil Code provides that a usufruct is extinguished, among others, by the termination of the right of the person constituting the usufruct. In this case, it is clear from the agreement that the usufruct was instituted for the benefit of the minor until he reaches the age of majority. Since the minor died before reaching the age of majority, the usufruct is extinguished because the purpose of which it was constituted was already extinguished. Question 9. Newlyweds Sam and Sienna had contracted with Sangria Hotel for their wedding reception. The couple was so unhappy with the service, claiming among other things that there was an unreasonable delay in the service of dinner and that certain items promised were unavailable. The hotel claims that while there was a delay in the service of the meals, the same was occasioned by the sudden increase of guests to 450 from the guaranteed expected number of 350, as stated in the bouquet and meeting services contract. In the action for damages for breach of contract instituted by the couple, they claim that the bouquet and meeting services contract was a contract of adhesion, since they only provided the number of guests and choose the menu. On the other hand, the hotel's defense was that the proximate cause of the complainant's injury was the unexpected increase in the guests, and this was what set the chain of events that resulted in the alleged inconveniences. Letter A. Does the doctrine of proximate cause apply? No. The doctrine of proximate cause is applicable only in actions for quasi-delicts, not in actions involving breach of contract. The doctrine is a device for imputing liability to a person where there is no relation between him and another party. In such a case, the obligation is created by law itself. But where there is a pre-existing contractual relation between the parties, it is the parties themselves who create the obligation, and the function of the law is merely to regulate the relations thus created. What applies in the present case is Article 1170 of the Civil Code, which reads, "Those who in the performance of their obligations are guilty of fraud, negligence, or delay, and those who in any manner contravene the tenor thereof, are liable for damages." Letter B. Was the bouquet and meeting services contract a contract of adhesion? If yes, is the contract void? Yes. A contract of adhesion is defined as one in which one of the parties imposes a ready-made form of contract, which the other party may accept or reject, but which the latter cannot modify. One party prepares the stipulation in the contract, while the other party merely affixes his signature or his adhesion thereto, giving no room for negotiation and depriving the latter of the opportunity to bargain on equal footing. However, contracts of adhesion are not invalid per se. Contracts of adhesion where one party imposes a ready-made form of contract on the other are not entirely prohibited. The one who adheres to the contract is, in reality, free to reject it entirely. If he adheres, he gives his consent. Sinclair and Steffi had an illicit relationship while Sinclair was married to another. The relationship produced a daughter, Sabina, who grew up with her mother. For most parts of Sabina's youth, Steffi spent for her support and education. When Sabina was 21 years old, Sinclair's wife of many years died. Sinclair and Steffi lost no time in legitimizing their relationship. After the 40-day prayers for Sinclair's late wife, Sinclair and Steffi got married without a marriage license, claiming that they have been cohabiting for the last 20 years. After graduating from college, Sabina decided to enroll in law school. Sinclair said that he was not willing to pay for her school fees since she was no longer a minor. Sinclair claimed that if Sabina wanted to be a lawyer, she had to work and spend for her law studies. What is Sabina's filiation status? Sabina is an illegitimate child under Article 165 of the Family Code. Article 165 states that children who are conceived and born outside a valid marriage are illegitimate. Sabina's father, Sinclair, was married to another woman at the time she was conceived and born. As no valid marriage could have existed between her parents during her conception and birth, Sabina is clearly born outside of a valid wedlock. Hence, Sabina is an illegitimate child. Her parents' subsequent marriage cannot accord to her legitimation. Under Article 177 of the Family Code, only children conceived and born outside of wedlock of parents who, at the time of the conception of the former, were not disqualified of any impediment to marry each other, may be legitimated. At the time of Sabina's conception, her father Sinclair is married to another woman, which means one of her parents has an impediment to marry the other. Hence, Sabina cannot be legitimated under Article 177. Letter B. Is Sinclair legally required to finance Sabina's law education? No. Under Article 194 of the Family Code, the education of the person entitled to be supported shall include schooling or training for some profession, trade, or vocation, even beyond the age of majority. The obligation of the parent to provide support for the educational needs of the child is only up to tertiary education. Since Sabina has necessarily finished obtaining a profession before entering law school, Sinclair is no longer obliged to finance the former's law education. Thus, Sabina can no longer demand support for her law education from her father. Question 11. Samantha sold all her business interests and a sole proprietorship to Sergio for the amount of $1 million. Under the sale agreement, Samantha was supposed to pay for all prior unpaid utility bills incurred by the sole proprietorship. A month after the contract to sell was executed, Samantha still had not paid the 50,000 electric bills incurred prior to the sale. Since Sergio could not operate the business without electricity, and the utility company refused to restore electricity services unless the unpaid bills were settled in full, Sergio had to pay the unpaid electricity bills. When the date for payment arrived, Sergio only tendered 950,000, representing the full purchase price, less the amount he paid for the unpaid utility bills. Samantha refused to accept the tender of the ground that she was the one supposed to pay the bill, and Sergio did not have authorization to pay on her behalf. Letter A. What is the effect of payment made by Sergio without the knowledge and consent of Samantha? B. Is Samantha guilty of mora accipienti? Letter A. Article 123(6) or 1236, number 2 of the Civil Code. Whoever pays for another may demand from the debtor what he has paid, except that if he has paid without knowledge or against the will of the debtor, he can only recover insofar as the payment has been beneficial to the debtor. In the problem, Sergio paid the utility bills without the consent of Samantha. He cannot demand from the latter what he has paid because the payment here cannot be said to have been beneficial to Samantha, because it can be inferred from the facts that she has the resources to do so. Letter B. Yes, Samantha is guilty of mora accipienti. Under the Civil Code, mora accipienti is delay on the part of the creditor without justifiable reason to accept performance of an obligation. In the problem, Samantha has the obligation as a creditor in the sale of business of sole proprietorship to accept the payment of Sergio, representing 950,000. The fact that Sergio paid her prior unpaid utility bills against her will is not a justifiable reason to refuse acceptance of compensation to their binding contract of sale. The following are the requisites of mora accipienti. 1. Offer of performance by the debtor who has the required capacity. Number 2. Offer is to comply with the prestation as it should be performed. And 3. Creditor refuses the performance without just cause. Question 12. Sachi opened a savings bank account with Shanghainese Bank. He made an initial deposit of 100,000. Part of the bank opening forms that he was required to sign when he opened the account was a holdout agreement, which provided that should he incur any liability or obligation to the bank shall have the right to immediately and automatically take over his savings account deposit. After he opened his deposit account, the Shanghainese Bank discovered a scam wherein the funds in the account of another depositor in the bank was withdrawn by an impostor. Shanghainese Bank suspected Sachi to be the impostor and filed a criminal case of estafa against him. While the case was still pending with the prosecutor's office, the bank took over Sachi's savings deposit on the basis of the holdout agreement. A. What kind of contract is created when the depositor opens a deposit account with the bank? B. In this case, did the bank have the right to take over Sachi's bank deposit? Letter A. The contract created when a depositor opens a deposit account with a bank is a simple loan or mutuum. Article 1980 of the New Civil Code provides fixed savings and current deposits of money in banks and similar institutions shall be governed by the provisions of concerning simple loan or mutuum. When a savings account is opened, a creditor-debtor relationship ensues with the depositor as the creditor and the bank as the debtor. Letter B. No, the bank had no right to take over Sachi's bank deposit. The holdover agreement states that the right may be exercised by the bank only after the depositor incurs any liability to the bank. In this case, the depositor is only suspected of estafa by another bank in the prosecutor's office. Absent a court order, the bank cannot withhold the deposit of the depositor. Question 14. Socorro is the registered owner of Lot A, while Segunda is the registered owner of adjoining Lot B. Lot A is located at an elevated plateau of about 15 feet above the level of Lot B. Since Socorro was allegedly removing portions of the land and cement that supported the adjoining property, Segunda caused the annotation of an adverse claim against 50 square meter on Lot A's transfer certificate of title, asserting the existence of a legal easement. Letter A. Does a legal easement in fact exist? If so, what kind? Yes. An easement for subjacent support exists. An easement for subjacent support exists when the supported land is above and the supporting land is beneath. In this case of easement, any stipulation or testamentary provision allowing excavations that cause danger to an adjacent land or building shall be void. Letter B. If a legal easement does in fact exist, is an annotation of the adverse claim on the title of the servient state proper? No. The annotation of an adverse claim on the title is not proper. It is well settled in the case of Castro versus Monsod that an annotation on the existence of the subjacent support is no longer necessary. It exists whether or not it is annotated or registered in the registry of property. A judicial recognition of the same already binds the property and the owner of the same, including his successors in interests. Question 15. Simon owned a townhouse that he rented out to Shannon, a flight attendant with Soleil Philippine Airlines, SPA. They had no written contract but merely agreed on a 3-year lease. Shannon had been using the townhouse as her base in Manila and had been paying rentals for more than a year when she accepted a better job offer from Sing Airlines. This meant that Singapore was going to be her new base, so she decided without informing Simon to sublease the townhouse to Sylvia, an office clerk in SPA. Letter A. Can Simon compel Shannon to reduce the lease agreement into writing? B. Does the sublease without Simon's knowledge and consent constitute a ground for terminating the lease? Letter A. Yes. Under the Civil Code, an agreement for the leasing of real property for more than 1 year is covered under the Statute of Frauds, which requires that the same should be reduced into writing in order to be enforceable. In this problem, the lease agreement between Simon and Shannon over a townhouse is for a period of 3 years. This gives Simon the right to compel the lease agreement into writing because the same is within the purview of Statute of Frauds. Letter B. Yes. Under Section 8 of RA 9653 or the Rent Control Act of 2009, subleasing a resident or a residential unit in whole or in part without the written consent of the lessor is prohibited. Accordingly, this gives the lessor a ground for terminating the lease as well as the ground for ejectment. Question 16. Selena was a single 18-year-old when she got pregnant and gave birth to Suri. She then left to work as a caregiver in Canada, leaving Suri with her parents in the Philippines. Selena, now 34 years old and a permanent resident in Canada, met and married Sam, who is a 24-year-old Canadian citizen who works as a movie star in Canada. Sam's parents are of Filipino ancestry but had become Canadian citizens before Sam was born. Wanting Suri to have all the advantages of a legitimate child, Selena and Sam decided to adopt her. Sam's parents, already opposed to the marriage of their son to someone significantly older, vehemently objected to the adoption. They argued that Sam was not old enough and that the requisite age gap required by the Inter-Country Adoption Act between Sam as adopter and Suri as adoptee was not met. Are Sam's parents correct? No. The parents of Sam are not correct. As a general rule, the Inter-Country Adoption Act of 1995 provides that any alien or Filipino citizen permanently residing abroad may file an application for inter-country adoption if the adopter is at least 27 years of age, at least 16 years older than the child to be adopted at the time of the application, unless the adopter is the parent of the child to be adopted or the spouse of such parent. Question 17. Sophia and Samuel, both unmarried, lived together for many years in the Philippines and begot 3 children. While Sophia stayed in the Philippines with the children, Samuel went abroad to work and became a naturalized German citizen. He met someone in Germany whom he wanted to marry. Samuel thereafter came home and filed a petition with the regional trial court for partition of the common properties acquired during his union with Sophia in the Philippines. The properties acquired during the union consisted of a house and lot in Cavite worth 2 million, and some personal properties including cash in bank amounting to 1 million. All these properties were acquired using Samuel's salaries and wages since Sophia was a stay-at-home mother. In retaliation, Sophia filed an action on behalf of their minor children for support. A. How should the properties be partitioned? The property should be partitioned equally under Article 147 of the Family Code. When a man and a woman who are capacitated to marry each other live exclusively with each other as husband and wife without the benefit of marriage or under a void marriage, their wages and salaries shall be owned by them in equal shares, and the property acquired by both of them through their work or industry shall be governed by the rules of co-ownership. For purposes of this article, a party who did not participate in the acquisition by the other party of any property shall be deemed to have contributed jointly in the acquisition thereof if the former's efforts consisted in the care and maintenance of the family and of the household. B. Should Samuel be required to support minor children? Yes. Parents and their illegitimate children, and the legitimate and illegitimate children of the latter, are obliged to support each other to the whole extent set forth in Article 194 of the Family Code. Article 195 of the Family Code. Question 18. Shasha purchased an airline ticket from Sea Airlines or SAL covering Manila, Bangkok, Hanoi, Manila. The ticket was exclusively endorsable to Siam Airlines SMA. The contract of air transportation was between Shasha and SAL, with the latter endorsing to SMA the Hanoi-Manila segment of the journey. All her flights were confirmed by SAL before she left Manila. Shasha took the flight from Manila to Bangkok on board SAL using the ticket. When she arrived in Bangkok, she went to the SAL ticket counter and confirmed her return trip from Hanoi to Manila on board SMA flight number SA888. On the date of her return trip, she checked in for SMA flight number SA888, boarded the plane, and before she could even settle in on her assigned seat, she was offloaded and treated rudely by the crew. She lost her luggage and missed an important business meeting. She thereafter filed a complaint solely against SAL and argued that it was solidarily liable with SMA for the damages she suffered, since the latter was only an agent of the former. Letter A. Should either or both SAL and SMA be held liable for damages that Shasha suffered? SAL should be held liable for damages suffered by Shasha. Sea Airlines or SAL as a ticket-issuing airline is the principal in a contract of carriage, while Siam Airlines SMA as the endorsee airline is the agent. Under Article 1910 of the Civil Code, the principal must comply with all the obligations which the agent may have contracted within the scope of his authority. The contract of air transportation was between Shasha and SAL, with the latter endorsing to SMA the Hanoi-Manila segment of the journey. Such contract of carriage has always been treated in our jurisdiction as a single operation. As the principal in the contract of carriage, SAL should be held liable, even when the breach of contract had occurred not on its own flight but on that of SMA. The obligation of the ticket issuing airline remained and did not cease, regardless of the fact that another airline had undertaken to carry the passengers to one of their destinations. China Airlines versus Chiyok. Letter B. Assuming that one is an agent of the other, is the agency coupled with interest? Yes. Where an agency is for the mutual benefit of the principal and of the agency is deemed coupled with an interest. The agent's interest must be in the subject matter of the power conferred and not merely an interest in the exercise of the power because it entitles him to compensation. SMA, as the agent of SAL and as an endorsee airline, has a personal interest in the business. It has assumed a personal obligation for the operation of the airline by undertaking to transport passengers from Hanoi to Manila. Its interest extends to the very subject matter of the transportation of passengers. As an airline company, for it undertakes to transport passengers from one destination to another. Sevilla versus Court of Appeals. Question 19. Sebastian, who was a pending assessment from the Bureau of Internal Revenue, BIR, was required to post a bond. He entered into an agreement with Solid Surety Company, SSC, for SSC to issue a bond in the favor of the BIR to secure payment of his taxes, if found to be due. In consideration of the issuance of the bond, he executed an indemnity agreement with SSC, whereby he agreed to indemnify the latter in the event that he was found liable to pay the tax. The BIR eventually decided against Sebastian and judicially commenced action against both Sebastian and SSC to recover Sebastian's unpaid taxes. Simultaneously, BIR also initiated action to foreclose on the bond. Even before paying the BIR, SSC sought indemnity from Sebastian on the basis of the indemnity agreement. Sebastian refused to pay since SSC had not paid the BIR anything yet, and alleged that the provision in the indemnity agreement, which allowed SSC to recover from him by mere demand, even if SSC had not yet paid the creditor, was void for being contrary to law and public policy. Can Sebastian legally refuse to pay SSC? No. Sebastian's argument has no merit. Under Article 27.3 of the Civil Code, when there are two or more guarantors for the same debtor, for the same debt, the one among them who has paid may demand each of the others the share, which is proportionately owing to him. In the problem, SSC as a guarantor, who bound to be solidarity liable with Sebastian, its cause of action is based on the surety bond that it posted to accommodate Sebastian pending assessment by the BIR. Sebastian's argument that SSC cannot recover from him because SSC has not paid anything from BIR is wrong. Here, BIR's foreclosure of the bond served as payment by SSC so as to allow him to recover indemnity from Sebastian based on the indemnity agreement. Question 20. Simon was returning to Manila after spending a weekend with his parents in Sarria, Quezon. He boarded a bus operated by Sabit Bus Line, SBL, on August 30, 2013. In the middle of the journey, the bus collided with a truck coming from the opposite direction, which was overtaking the vehicle in front of the truck. Though the driver of the SBL bus tried to avoid the truck, a mishap occurred as the truck hit the left side of the bus. As a result of the accident, Simeon suffered a fractured leg and was unable to report for work for 1 week. He sued SBL for actual and moral damages. SBL raised the defense that it was the driver of the truck who was at fault and that it exercised the diligence of a good father of family in the selection and supervision of its driver. A. Is SBL liable for actual damages? Moral damages? B. Will SBL be liable to pay interest if it is required to pay damages and delays in the payment of the judgment award? What is the rate of interest, and from when should the interest start running? Letter A. Yes. SBL is liable to pay actual damages. Article 1759 of the New Civil Code provides that common carriers are liable for the death or injuries to passengers through the negligence or willful acts of the former's employees. Although such employees may have acted beyond the scope of their authority or in violation of the orders of the common carriers. The liability of the common carriers does not cease upon the proof that they exercised all the diligence of a good father of a family in the selection and supervision of their employees. As to the actual damages, Article 2199 of the new Civil Code provides that, except as provided by law or by stipulation, one is entitled to an adequate compensation only for such pecuniary loss suffered by him, as he has duly proved. In this case, the actual damages are lucco cessante, or the loss of a benefit that the plaintiff failed to receive. As to moral damages, the same may be recovered in breach of contract of carriage only if the defendant acted fraudulently or in bad faith. In this case, since the accident was caused by the truck and not the driver of the bus, SBL is not liable to pay moral damages. B. Yes, SBL will be liable to pay interest if a judgment to pay damages is given and it delays it in the payment of such damages. When the judgment of the court awarding a sum of money becomes final and executory, the rate of the legal interest shall be 6% per annum from such finality until its satisfaction.